The first thing to take from the 2012 Kansas Court of Appeals case Giles v. Giles Land Company is that mixing family and business is a recipe for drama and dysfunction. At their best, family businesses are a vital part of our economy and society, responsible for 78% of all new job creation, outperforming other businesses in long-term financial performance, and providing workers with greater investment and loyalty. At their worst, the commingling of family dynamics and business dynamics can create some of the most bitter legal disputes. Giles v. Giles Land Company illustrates the latter. The second thing you should take from this case is that, in a business partnership, you should not be a complete prick to your fellow partners, as courts may decide to kick you out and leave you high and dry. The plaintiff in Giles, through his actions, ended up not only alienating the rest of his family, but depriving himself of an important business interest. When I read this case in my business associations class, it stuck with me on a personal level because of the family dimension. I think family is extremely important, and the way this case unfolded was very intriguing, helping me remember the legal lesson it teaches about partnership dissociation. As Carrie Fisher once said about a crappy movie that shall not be named,
"It's about family, and that's what's so powerful about it."
Our dispute involves a ranching family and their shared ownership of a limited partnership. Norman Lee Giles, the family's patriarch, is a third-generation cattleman in southwest Kansas. Born on July 8, 1924, Norman's family had been in the cattle business since 1878, when Norman's grandfather, George, moved from Illinois to Burdett, Kansas. At that time, the state of Kansas was only 17 years old. After marrying his high school sweetheart, Dolores, in 1943, Norman Lee expanded the family's operation to include ranch land and farmland stretching over 4 counties: Clark, Ford, Hodgman, and Edwards County. The family's operations include raising Black Angus cattle, alfalfa, and wheat. Norman and Dolores had 7 children: Norman Roger, Lori, Trudy, Audrey, Jody, Kelly, and Julie. As you can see, they were big fans of the E ending for names. Sometime in the mid-90s, the Giles Land Company, the defendant entity in this case, was formed as a limited partnership, owning some of the family's ranch land and farmland in Kansas. In corporate law, a partnership is an association of 2 or more persons to carry on as co-owners a business for profit. A limited partnership is the same as a regular or general partnership, except there are 2 classes of partners: limited and general partners. Both have rights to the partnership's profits, but limited partners have no management control, and only general partners are liable for the partnership's debts. Norman Lee and Dolores gifted general partnership interests to Norman Roger, Lori, and Kelly. On March 26, 2007, the family members held a meeting to discuss whether they should convert Giles Land Company into an LLC, or a limited liability company. The second youngest of the children, Kelly, was unable to attend the meeting, but received a letter explaining the discussion. Kelly refused to agree to the conversion and instead requested that he be able to review all of the partnership's records. Kelly appears to be somewhat of a black sheep of the family. In 1999, he incurred so much debt while a partner of the Giles Ranch Company, which is another Giles family business, that he had to be bought out of the ranch company by the rest of the partners. That same year, he moved to the town of Canyon, Texas with his family and started an Angus cattle ranch. I assume his geographic distance from the rest of the family was why he was unable to make the Giles Land Company meeting. According to Kelly's appellate brief, after he requested to review the partnership's records, Lori Giles and her husband, John Horacek, called Jerry Bond, a business partner of Kelly's. During the call, John speculated that Kelly was going to sue his parents and inquired about his financial and medical condition, asking Jerry whether Kelly was bipolar. Audrey Giles also allegedly hired a private investigator to investigate Kelly, and Norman Lee and Dolores transferred limited partnership shares to all of their children except Kelly. When Kelly wasn't satisfied with the records given to him, he sued the Giles Land Company, asking the court to force the partnership to give him all the requested records. In response, the rest of the family, as the partnership, sought to dissociate Kelly from the partnership. Basically, the family wanted to kick Kelly out and strip him of his interest in the business. In the Ford County District Court, Judge Daniel L. Love found that the partnership properly complied with Kelly's document requests. Judge Love also held that Kelly should be dissociated from the partnership. Because of Kelly's threats and the total distrust between Kelly and his family, the partnership was unable to function unless Kelly was removed from being a partner. We will get into what exactly Kelly's threats were later. The statute relied upon in Judge Love's decision is Kansas Statute 56A 601, which governs the dissociation of partnerships. The relevant sections state that, quote, "A partner is dissociated from a partnership upon the occurrence of any of the following events: on application by the partnership or another partner, the partner's expulsion by judicial determination because the partner engaged in wrongful conduct that adversely and materially affected the partnership business, or the partner engaged in conduct relating to the partnership business which makes it not reasonably practicable to carry on the business in partnership with the partner." The language of this statute comes from the Revised Uniform Partnership Act, which Kansas adopted in 1998. The Uniform Partnership Act is a model act drafted by the Uniform Law Commission, or ULC. The ULC drafts these model acts to provide clarity and uniformity in the laws of the 50 states when desirable. States are free to adopt the model acts or not, and can revise them when adopting them as state law. The 1914 version of the Uniform Partnership Act has been enacted in all 50 states except Louisiana, because Louisiana is weird in French. The most recent version, the 1997 Revised Uniform Partnership Act, or RUPA, has been enacted in 37 states, including Kansas. Specifically, Judge Love found that Kelly should be dissociated because of Section E3 of the statute, where a partner can be dissociated because the partner engaged in conduct relating to the partnership business which makes it not reasonably practicable to carry on the business in partnership with the partner. Under this section, the evidence must show that 1. Kelly engaged in conduct relating to the partnership, and 2. The conduct makes it almost impossible to carry on the partnership's business with Kelly still as a partner. The trial court found that Kelly and the rest of the family did not trust each other, and that the relationship between Kelly and the rest of the family was irreparably broken. One particular event was proffered as evidence for this broken relationship. During a 2006 meeting, Kelly allegedly said that the other Giles Land Company partners, his siblings and parents, would each die in turn, and that he would be the last man standing, and that he would then get to control the partnership. Although Kelly claimed that he was simply explaining how the right of survivorship works, the rest of the family took it as a threat. Evidence also showed that Kelly said that paybacks are hell, and that he intended to get even with his partners. Kelly's version of the events, according to the trial court, was that he was something close to the magnanimous savior of the family, which the court found not credible. The rest of the family disagreed with Kelly, with each of them testifying that he or she believed that it was in the best interest of the partnership to not have Kelly remain a partner. The trial court also found that Kelly could be dissociated under Kansas Statute 56A 601E1, which requires evidence that 1. Kelly engaged in wrongful conduct that 2. Adversely and materially affect the partnership business. The wrongful conduct centered on Kelly's interactions with his parents, Norman Lee and Dolores. Kelly's sister, Lori, testified that Kelly frequently berated his parents to get his way. Lori's husband, John, related a telephone conversation where Kelly reduced his father to tears by the end.
Why am I toxic? What?
I can't imagine what I would have to say to my father during an argument to get him to cry. That is some next level fighting. By the end, apparently most communications with Kelly had to be conducted through his lawyer. Because of all this evidence, Judge Love found that Kelly should be dissociated from the partnership in an order dated December 9, 2010. On December 20th, Norman Lee Giles passed away at the age of 86. Sometime between December 2010 and December 2011, Kelly was removed as a partner in Giles Land Company. On January 26, 2011, Kelly Giles appealed to the Kansas Court of Appeals the holding that he be removed from the partnership. Located in Topeka, Kansas, the Kansas Court of Appeals is Kansas's intermediate appellate court. Like federal appellate courts, the Kansas Court of Appeals has a panel of 3 judges that hear a case, which are picked randomly from the 14 judges on the full court. The judges hearing this case are Chief Judge Richard D. Green, with an E, Judge Henry W. Green Jr., with no E, and Judge Michael B. Buser. None of these judges are currently on the court. Judge Buser and Judge Green with no E retired in 2022 and 2025, respectively. Chief Judge Green with an E passed away on October 7, 2012. On appeal, Kelly's argument regarding the Section 601(e)(3) dissociation was that the evidence the trial court relied upon did not relate to the partnership business and was not relevant in deciding to dissociate Kelly from the Giles Land Company under the Uniform Partnership Act. For the Section 601(e)(1) dissociation, Kelly argued that the conduct was not wrongful and, even if it was, that it did not affect the partnership business. According to Kelly, the evidence showed that the partnership continued to operate normally. On June 15, 2012, the Kansas Court of Appeals published its opinion, written by Judge Green with no E. The court ruled against Kelly on the argument that his conduct did not relate to the partnership business, considering the evidence. Remember, since the Court of Appeals is an appellate court, it can only look at the facts as determined by the trial court. The partnership was a family partnership, with all the partners being family members, and so the conduct was related to the partnership business because it involved disputes between the family members. The relationship between Kelly and the rest of the family is broken, and the animosity and distrust Kelly and the rest of the Giles family hold against each other prevents the two parties from being able to do business. In fact, the court found that the partnership could not perform important business because of a failure to communicate between Kelly and his partners. The court also notes that the evidence showed a naked ambition on Kelly's part to control the partnership, contrary to the interests of the other partners. Therefore, the court holds that the appropriate action is to dissociate Kelly from the partnership under the statute. The court also finds that Judge Love could dissociate Kelly from the partnership under Section 601(e)(1, considering the evidence. Kelly's berating and threatening of his parents qualified as wrongful conduct because the partnership was a family partnership. There was also evidence that Kelly's actions were adversely or materially affecting the partnership. Norman Lee testified that the partnership was at a standstill because of the dispute between Kelly and the rest of the family. The dysfunction, animosity, and lack of trust between Kelly and the rest of the partners was preventing the partnership from functioning properly, and so Kelly could be forcibly removed from his position as partner. After the Court of Appeals decision, it appears that Kelly Giles and the rest of the family remained distant. Giles Land Company was reorganized into an LLC, and it remains active to this day. Norman Roger, the eldest son, and his family operate part of the Giles Ranch operation, while daughter Lori and her family operate the other parts. 5 years later, tragedy would strike the Giles family ranch. On March 6, 2017, a devastating wildfire raged through the Giles Ranch operated by Norman Roger and his family, scorching almost 30,000 acres. 3 members of the family lost their homes in the blaze, and numerous other ranch buildings also succumbed to the fire. However, the loss of animal life was considered to be the worst. The ranch lost half of their cattle herd, 4 horses, a donkey, and the family dog to the fire. The fire burned more than 80% of the land in Clark County, Kansas, around 600,000 acres, and is considered the largest fire to hit Kansas. Luckily, none of the members of the Giles family were physically injured, and they were able to recover, thanks to help from the local community. The family was able to move back into their rebuilt homes by April 1st of 2019. Kelly Giles continued to operate his ranching operation in Texas and involved himself with politics in the Amarillo area. This political involvement would lead him to further, ongoing trouble with the legal system. On June 25, 2025, a Randall County, Texas grand jury indicted Kelly on 1 count of election fraud related to the 2024 election. At the time, he was the Randall County Republican Party chairman, serving since the County Executive Committee elected him in May of 2023. During the March 2024 primary election, he was re-elected as party chairman with 51% of the vote. According to the indictment, Giles is accused of knowingly or intentionally falsely certifying with the Texas Secretary of State that his application and nominating petition were legally compliant to be placed on the 2024 primary ballot. This would normally be a misdemeanor, but since Kelly was an elected official at the time, the offense is upgraded to a state jail felony. On July 7, 2025, Kelly was booked into jail, although he was released the next day. The case is currently ongoing. When familial and business relationships mix, it can lead to some of the most bitter disputes. When the disputes between partners in a partnership become so severe that the business of the partnership cannot go on, most states have laws, like those under RUPA, that will allow the courts to forcibly dissociate partners if one of the partners asks for it and it meets applicable standards. Dissociation of a partner from a business partnership is appropriate if the partner engages in conduct relating to the business partnership that makes it not reasonably practicable to carry on the business in partnership with the partner. Kelly Giles' threats to and fights with the rest of his partners, who were his family members, caused the Giles Land Company to be unable to carry out its business. The court thus saw it fit to remove him from the partnership. So ends our discussion of the sad family drama of Giles v. Giles Land Company. Until next time, I'm Lex Ursa. Have a nice day.